Okay, so just to go into like a little deeper, with a little bit more detail regarding what I was talking about. So in my motion, this is my motion. I had described the situation, and this is pretty much what I said. At the conclusion of the evidentiary hearing on September 8th, 2025, blah, 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 the order states in pertinent part the following. Mother is in contempt for parenting time violations that appear to cause unnecessary frustration of father. And then number 2, the order found mother in contempt based on the following. Parenting time was ordered. Mother violated the parenting time order on October 28, 2024, because the child was not taken to daycare, but failed to notify father and instead manipulates the order, which effectively sends father to various locations for the child due to mother's lack of appropriate communication. I go on to state, although the court found mother in contempt for an October 2024 incident, this was in error. Indeed, as the evidence presented at the evidentiary hearing showed, it was father that actually did not take the minor child to daycare on October 28, 2024. See Trial Exhibit R4, which is my exhibit. There was no dispute at trial that this occurred during father's parenting time. As such, this was a misapplied fact and contradicts a finding of contempt against mother. Continue to state, the messages in Exhibit R4 show that on October 2024, it was actually father causing, quote, unnecessary frustration onto mother, not the other way around. Father did not take the minor child to daycare or even have her enrolled and failed to notify mother of this. Father's failure to appropriately communicate and notify mother effectively sent her to, quote, to various locations for the child. This is consistent with mother and father's testimony at the evidentiary hearing. So I go on to, I copied the trial transcripts in regards to my direct examination, and I go on to talk about that exhibit that I presented. And then in father's direct examination from his attorney, says, okay, now she did bring up that there were 2 incidents that you had the child picked up at different places. Is that correct? And he says, that's correct. His lawyer then asked, one was in October of 2024. Is that correct? And he says, yes. And all right, there's another one, whatever. Okay, so father admits to it, and I've already talked about it like I stated. And then I go on to state, mother also provided another example from March 3rd, 2025, which proved that father attempted to manipulate the court order and send mother to various locations as a result of untimely notification. See Trial Exhibit R9, Bates 421. As mother was arriving at mother's home in a location that is an hour and a half away from me, father messaged that his mother was at his sister's home, and that I would have to pick up there, that mother would have to pick up there, which would have increased my one-way trip from approximately 70 miles to 100 miles. I refused to drive to multiple excessively distant locations, and therefore I lost parenting time as a result of father waiting, or as a result of me having to wait for his mom to return back to her home so that I could get my child. I said, to note, father testified that mother did not timely notify him of exchange and requested the court that mother be required to provide notification, but did not provide evidence of mother not providing timely notification of those, quote, exchanges, which he never proved in court. However, I was able to provide evidence of father doing what he was alleging me of doing. Father testified that untimely notification was a violation of the court order and was unreasonable. So he testified to that, yet he was doing that to me. And we go on to talk about the exhibit that I had and about it increasing my mileage. And so I was requesting the court to amend the judgment to reflect that father, not mother, was in contempt for parenting time violations based on the evidence and testimony obtained in trial. Father testified that the acts of untimely notification was a violation of the court order and unreasonable. Also, father did not contest the evidentiary facts related to the violations that occurred in October 2024 and March 2025, and did not have evidence to contradict mother's testimony or the evidence she provided. And so I was requesting that the court change the order to say that he was held in contempt for a second time. Oh, sorry. That he already had 2 counts of contempt, I guess, based on what the order said. And so because that was an error, I was requesting that the judgment reflect that he's actually being contempt 3 times, not 2 times. And that was denied. And I have other things in here regarding other stuff that I'm going to discuss later. But that just kind of gives a little bit more detail as to how I presented the material. And it was, like I said, black and white. And I'm going to go into other aspects of my case. But I wanted to start with this one just because I feel like if I talked to Joe Schmo on the street and I said, hey, you know, this happened, would you think that it would be an accurate statement to say that the court would have to change this? And so that's why I wanted to start off with this, because there's other aspects of my case that may not appear to be black and white because of if somebody doesn't know the history and doesn't know everything that's occurred, which has been a lot, then it may not appear to be as black and white. But I felt like starting off with this would be a really good example to show how something so simple can just go wrong and leave somebody kind of like dumbfounded. Like, really? Like, you're not going to just change this? You're not going to hold yourself accountable to making this adjustment because it was an error on your part? And yeah, so I was just kind of like, you know, that's kind of like what set all of this in motion, because I'm like, this is plain and simple. Like, it's very direct, very obvious. And so, yeah, so that's why I was starting with this. But like I said, I will be going into more aspects of the case. And because I've been told, like, you know, well, you need to start from the beginning. Like, if I started from the beginning, then it would be way too long to get to this point. So I wanted to start with something plain and simple. And like I said, I will be going into other aspects of my case and things that I've experienced, so that people can get a better understanding of why I'm feeling the need to do this and go about it this way, I guess. Anyways, yeah, hopefully that helps a little bit.